If you were to consider the evidence presented by the state, with the exception of the interview with Ms. Sesmas, I would suggest to you that from that evidence, you could eliminate reasonable doubt as to whether or not Ms. Sesmas was guilty of premeditated first-degree murder. But you do have the interview. We need to talk about it and decide whether or not, or you need to decide whether or not the evidence presented in that form eliminates reasonable doubt. When we talk about the evidence through the interview with Ms. Sesmas, I would suggest to you that the first thing you need to do is decide how to determine the credibility of what she said. There are a number of things that we typically use in our daily life that y'all don't have available to you. We don't have past experience with Ms. Sesmas. There isn't any published works about her. It is simply what is corroborated and what makes common sense. I think those are the two things that you need to consider most. So, let's look at some of the statements. Laura was going to give me the baby girl. Y'all have to decide whether or not that was true. When you are trying to decide, remember how Laura and Manuel's home was prepared for the child. Remember what was said by Laura to the defendant in their chats. I'm looking forward for Victoria. Her dad wants her to be out. He's so happy. We want to have her here so much. Ladies and gentlemen, I would suggest that those are not the preparations, those are not the statements, those are not the proof that Laura was going to give up her child. The testimony of her mother, the testimony of Manuel, both of those folks said she was really, really looking forward to raising Sophia. So when you are determining the defendant's credibility, think about those things. I brought the gun to scare her. If there had been an agreement, why would there be a need to scare? If there had been an agreement, why would the defendant have had to purchase this gun 3 or 4 weeks beforehand? Why would she need to know that it was loaded? Why didn't she just use that? The pellet gun found on the floor of her house in Dallas, Texas. The Plainview guy. Defense concedes that that was simply a construct. So they would have you just disregard that. But I would suggest what you should do with the Plainview guy story is to use it in determining, number one, whether the defendant was willing to come up with a scenario where she was trying to avoid responsibility for her actions. Was it a scenario that she thought would take attention away from her? Was it a scenario that has other implications as far as other things that the defendant said. For example, the gun went off. Can you use the defendant's construct of the Plainview guy in the red Pontiac in determining whether or not she was being truthful with the detectives when she said the gun went off? How much common sense does it make for the gun to have just gone off? You heard Mr. Rankin's testimony that there are 2 different safeties on this weapon, that in order to disable both of those, the trigger had to be pulled back completely, and then the gun would fire. He said the reason for those safeties are to keep the gun from going off if it's dropped, if it's bumped, if something other than pulling the trigger completely happens. And remember too what he told you about what it took to pull that trigger. 6.5 pounds of pressure. Consider what 6.5 pounds on your finger would feel like. We all have experience going to the grocery store, buying, canned vegetables. Roughly a pound a piece. 6.5 times that much pressure to pull the trigger completely. Would the gun just go off? The defendant would ask you to look at missing evidence. In questioning Detective Palmer, one of the things her counsel asked about was, did you find anything at the house in Texas or the apartment in Wichita that had a written, premeditated plan for murder? And she said no. And I would suggest to you that you were probably sitting there thinking, well, who would ever do that? It's one of those things that doesn't make common sense. If you're going to kill someone, you aren't going to set out a written plan for someone else to find. But was there writing to indicate the premeditation of Ms. Sesmas? Does your boyfriend work in the morning? What day is your boyfriend off work? I made an error here. I put in does this place have security? That was not written. That was said the day before. I keep you company when you're alone. All of those messages and statements indicate that the defendant was searching for a time when it would be her, Laura, and the baby, with no other interference. A written plan of premeditation. Says there's no evidence of ambush. Ambush, at least I would think, or I would suggest that a common meaning of ambush means a person lying in wait for another person to come, or setting a trap around another person. And there's no evidence of Ms. Sesmas doing that. However, I'm going to be by myself on Thursday. That's a message from Laura to the defendant. That's a message which eliminates the need for an ambush. She doesn't have to lie in wait. She can just go there because because Ms. Barca has already told her. It's going to be me, thank you, it's going to be me and Sophia here alone. Defense counsel made some issue of not attempting to destroy the phone. First of all, we have no idea how advanced the knowledge of Ms. Sesmas regarding phones is. Did you sit there and listen to the people who talked about what information came from a cell phone and think, wow, that's a lot more than I realized would be possible? And if you did, would it be unreasonable for Ms. Sesmas to be thinking the same thing? So perhaps she just didn't know what was possible. Or perhaps she needed her phone with the same WhatsApp application and in the same series, that would show the same series of messages to show that she was trying to mislead the investigation by heading the opposite direction. No attempt to conceal identity. Well, which would create the most identity issues? Her coming as the friend of the victim, or her coming as a masked and gloved person to invade an apartment in the apartment complex? I would suggest that the evidence shows that she didn't disguise herself because she did not expect there to be a witness. She expected Laura would be dead. Thank you.